Good morning, friends. Today we are going through one another case law, which is a very important judgment of 2022. Janhit Abhiyan versus Union of India. It is a writ petition with number 55 of 2019, November 7, 2022. We'll go through a brief outline of this. After passing of Constitution 103rd Amendment Act 2019, several writ petitions and special leave to appeal were filed in order to deem the said amendment as unconstitutional and a breach of basic structure doctrine. By virtue of this amendment, the state became empowered to make special provision regarding reservation for the economically weaker section with an upper limit of 10% by virtue of addition of articles 15 clause 6 and 16 clause 6 in Constitution of India. Thereby, the state has been empowered to give a 10% reservation to economically weaker section of the society in the educational institutions and employment opportunity in exclusion of scheduled caste and scheduled tribes and non-creamy layer other backward classes. So, this is regarding 103rd Amendment of Constitution, where it has been provided that 10% in addition to the reservation which have been provided to the scheduled caste and scheduled tribe under Indian Constitution, it is to be provided to the economically weaker sections so as to uh, put them in the mainstream because they are facing the poverty and in the articles 15 clause 6 and 16 clause 6 they have been empowered that they could get the admission in the private aided institutions and also in the public employment they could get the reservation, and that reservation is 10% in addition to 50% of reservation which has already been provided to the other castes. What are the issues involved in it? So first issue which is involved in it, economic criteria cannot be sole determinant in allowing reservation for a particular section of society, and thus it infringes the basic structure of constitution. Second issue involved is exclusion of socially and educationally backward classes, that is SCs, STs and OBCs from these special provisions for EWS is inexplicably discriminatory in nature and thus violates the basic structure of the constitution. The third issue which was involved here was the defined 10% upper limit of reservation for the EWS directly breaches the 50% cap of reservation and hence directly goes against the ethos and jurisprudence of reservation as espoused by the constitution makers, as it violates the equality code and thus again violates the basic structure of constitution. So there are three issues involved here. We'll see what were the arguments for this from the side of petitioner here. So, the first argument was the reservation granted by Constituent Assembly in 1949 to the backward classes of the society was based on age old discrimination suffered by these communities. The rationale behind such a measure was to give them an equal playing field, provide equal representation, and address the historical inequalities suffered by backward classes. The petitioners further argue that court must exercise purposive interpretation of reservation considering EWS and revisit the purpose behind the reservation policy through the vision of constitution makers and constituent assembly debates. On the other hand, 103rd Amendment aims to extend the reservation to a class of people which was never marginalized or discriminated against, and hence such an amendment defeats the very rationale of reservation policy. It was further submitted that constitution endorses the concept of social and educational backwardness rather than social or educational backwardness, which tells us that social and educational criteria are not mutually exclusive of each other, and both needs to be fulfilled in order to claim reservation by a certain class of people. In the arguments from the side of respondent, learned Attorney General of India, Mr. K. Venugopal, contended that the said amendment vitalizes the basic structure of constitution rather than breaking it. An amendment to the constitution may be struck down only when it is capable of changing the identity of the constitution. The classification based on economic criteria alone is justified. The Supreme Court has considered poverty as an indicator of backwardness while considering reservation in several cases, such as M.R. Balaji, R. Chitralekha versus State of Mysore, and Vasant Kumar. It is further argued that it is poverty that leads one to social and educational backwardness, and the said amendment tries to cure such a discrepancy by creating a class of people which are in fact socially and educationally backward due to economic equality faced by them in the society. Therefore, the parliament is in the right to create such an enabling provision which minimizes economic inequality in the society. So, in the arguments from the side of petitioner, we can see that they are providing the contention that it is an age old discrimination which the communities are suffering, and that is why the reservation has come. And in the contention provided by the respondent here, Mr. Venugopal contends that the amendment to the constitution is very much uh, better for the betterment of the economic condition of the communities which are socially and educationally backward. Along with that economic inequality, they are emphasizing here that most of the people at this point of time are suffering from poverty and inequality in the respect of economy, whereas the economic inequality is considered faced by them. The parliament is in the very right to create such an enabling provision to minimize the economic inequality in the society. So what was the judgment in it? So Supreme Court has held that 103rd constitutional amendment cannot be said to breach the basic structure of constitution by permitting the state to make special provision in relation to admission to private unaided educational institutions. I have given here 5 points in which we will discuss about how Supreme Court has reached to this judgment. The Supreme Court, through an 3:2 majority, upheld the constitutionality of 103rd amendment to the constitution on the questions of basic structure of constitution. So as far as the basic structure of the constitution is considered, we will discuss what Mrs. Bela Trivedi, Justice Bela Trivedi, has said about it. It is for providing reservation by way of affirmative action, being exception of right to equality, and cannot be treated as a basic structure. It is an enabling provision only and cannot be regarded as basic feature of constitution. This was said by Justice Bela Trivedi. Also, as far as Justice Pardiwala is considered, he has said that it is a transformative constitutionalism which we'll have to focus here, as the special provision in respect of reservation provided under 15 and 16 indicates that, and we need to revisit system of reservation, which is age old discrimination against some classes. But now poverty is also one of the major drawbacks in achieving the equality in the society. So in order to lead towards more egalitarian, casteless and classless society, it is important that we uh, enact one amendment which is taking care of the economic equality in the classes. So with the ratio of 3:2, SC has held that 103rd Amendment is constitutionally valid. The second point is discrimination due to exclusion of SC, ST, and OBC, SEBCs in the 10% quota of EWS reservation. So, as Justice Bela Trivedi has said, that it is only an enabling provision and it is not in the discrimination of the Constitution, as it is not a basic feature of the Constitution. So, 10% quota of EWS reservation, it is not in the discrimination of 50% reservation, which was provided in M.R. Balaji versus Union of India and Vasant Kumar versus Union of India. The third point is economic criterion as the sole criteria to provide reservation under 15 clause 6 and 16 clause 6 of constitution. Again, I will cite two cases, MR Balaji versus Union of India and Vasant Kumar versus Union of India, where economic criteria was considered to provide reservation under articles 15 clause 6 and 16 clause 6. So, the next one is application of 10% EWS reservation on private unaided educational institutions. So the same is upheld in the given decision. After understanding and analyzing the nuances of 103rd Amendment to the Constitution, which introduces reservation to the economically weaker sections of the society under Articles 15 Clause 6 and 16 Clause 6, one may be able to deduce that India is still suffering from rampant poverty and needs strong measures to extend the social and economic benefit to every strata of society. The state must ensure social mobility in order to lessen the chasm between the rich and poor so that a homogeneous society may be created. Supreme Court has interpreted the amendment in such a manner that it may fulfill the preambular goal of rendering economic justice to all. Parallelly, the dissenting opinion of CJI UU Lalit and Justice Ravindra Bhatt signifies the historical essence of reservation as a preparation to those invariably discriminated by virtue of their caste. We'll also see the minority opinion. Chief Justice of India at that time, Mr. UU Lalit and Justice Ravindra Bhatt collectively held that 103rd Amendment is violative of basic structure of Constitution on the following grounds: that the exclusion of SC, ST, OBC and socially and educationally backward classes is completely against the Equality Code, which is essential to the nature of Constitution. It is believed that such an exclusion is a furtherance of discrimination against the historically disadvantaged and deprived community. The 10% reservation disallows such communities to not compete outside their allocated reservation quotas, which is arbitrary in nature. However, there seems to be no disagreement with regard to providing reservation through Article 15 solely on the basis of economic criteria. The court realizes this through dynamic interpretation. One may include economically weaker section as a part of backward class which is not able to afford the benefit of education, hence get forever stuck in the vicious cycle of poverty. However, the dissenting judges believe that such a reservation is not allowed under Article 16 of the Constitution, which talk about equality of opportunity in employment. The rationale behind this provision is to provide representation to the historically disadvantaged and weaker section of society, thus giving reservation on the sole basis of economic criteria would be against the ethos of constitution, which aims to provide equal representation to all the classes of society.